You made it. Good deal. I wasn't worried about you either way. All right, court is now on docket and on record on the docket for the criminal cases. And we have any attorneys that are ready? No one's ready? Who are we ready on? Gustavo Miguel Castillo, CR 22-319. Yeah, let's let him get in place. Go ahead, Mr. Castillo, right behind the computer there. All right, this is a hearing on the state's motion to revoke. Go ahead, Mr. White.
That's correct. It's outdate that the state has become aware of fairly recently. And they also involve a possibility of a situation in Rockwall County. As a practical matter, I come up here and I win this as completely as you can, and then it goes to Rockwall, and things don't go as well. We basically wait some time. He has a hold on in Rockwall right now. He is in no bond right now. One of the things I would point out to the court under 42A75(1), violations of conditions of supervision. There is a bit that says that the hearing has to be held in 20 days of his incarceration, or possibly whenever the motion to revoke was. But the remedy is not for it to be dismissed, and the remedy is for it to be bond to be set. And we were thinking the possibility that if we had bond set here, the situation might be transferred back to Rockwall, where that would probably make a decision on how this can be resolved. And I don't believe the state has any opposition to that idea.
State.
That's correct, Ron.
You don't have any opposition to the court granting bail on your motion to revoke and letting him go to Rockwall where he's got new charges?
That's correct.
And what are the charges in Rockwall? Are they higher than a second-degree felony?
I think they may be lower than that.
So they're lesser charges than the one we have here? I think maybe the alternative would be let's just set him for a contested hearing in 2 weeks on the 27th. And then whatever disposition you get here could resolve the ones in Rockwall.
Well,
I mean, it just doesn't make sense to me that we would give up a higher charge for a lesser charge in another county when we have him here, and the state's the one that filed the motion. The court didn't file the motion.
this situation about resolved. I'm not very familiar with what's going on, so another larger and I haven't talked to them recently, and I know that it hasn't been resolved at all. One of the things, just as a practical matter, is difficulty that the state may have in trying to get officers from another county to come down here and testify.
And I'm very well aware of what the state's burden is. I sat in that seat for 15 years. I know what they got to do, but my concern is that we would be granting some kind of bond, PR bond, to send him to another county on charges unrelated to ours that are lesser than the second-degree felony here that the state filed this motion, and they're the ones that brought him to court.
Go at the But as I was telling you, this is just, an alternative situation that I want the board to consider.
No, I understand. I would, I would decline to set bail on Mr. Castillo on the state's motion to revoke. I understand that he's got other charges in other counties, but that's independent of what my responsibility is here to Van Zant County, for these charges. So, and it doesn't sound like there's being a global plea is being worked on to resolve these cases and those cases. If that were the matter, then perhaps that would be more persuasive to the court, but giving up our case to let him go work on another county's cases seems to be the opposite of what I should be doing.
I'm certainly not going to tell you how to do it.
Yeah, and I appreciate that. So what I'm going to do is I'm going to set Mr. Castillo then for contested hearing in 2 weeks on the 27th, and the state can present their evidence. And if there's a resolution on that date, then court will hear it on that date.
That is on the third.
Yes, sir. Thursday at 1:30, 2 weeks. The 27th, August 27th at 1:30.
And that'll be 1:30?
Yes, sir.
Yeah, I'll get this.
Okay. Mr. Manning, are you still working? Do you need time? Well, if you need time, that's fine. I've got Mr. King on Zoom, but I always like to get the attorneys that are in person first.
Yes, that's what. Sean Davis and some of the resets. I will clear out some of the jail name.
All right, Mr. Davis, if you'll come up. All right, court is calling cause numbers CR 2395, CR 23207, CR 23208, CR 23209, State of Texas versus Sean Ray Davis. This was set for plea today. The court had announced its non-acceptance of the proposed plea agreement offered by the state and the defense. Any further announcement, Mr. Manning?
At this negotiation date, they have proposed making this first resolution on this. And so this, I believe, will be August 31st of setting, before trial. We still hope to resolve this case, with a plea resolution. I don't know if the state and defense would, if the court would like for us to proffer that for consideration to this court, or let this court know where proposed are as we reach this agreement on the road, or if we like to just set it for another second prior to them.
If you want, we can set it for status on the 27th. And then if you don't have a resolution on that date, then we can continue it to trial on the 31st.
I will reset agreements.
All right, court will set Mr. Davis on status for disposition August 27th at 9 a.m.
Then next, ready. Baker.
Michael Glenn Baker, CR 26-7, CR 26-41. Mr. Baker here. Oh, I'm sorry, I couldn't see him. Okay, my bad. You're good. All right, Mr. Baker set for a docket call on the assault and a pretrial on the sexual abuse of a child. All right, court finding there are no contested pretrial motions. The court sets Mr. Baker for final docket call on October 15th. That'll be at 1:30 if he's still in jail.
That I don't see this form here.
It's my information from staff that Ms. Cormier has politely declined her appearance today by saying no, thank you. So as counsel, do you waive her appearance today? I think we're just set on a status for her wait list.
Correct.
That's the most updated information I have.
Then, as for competency restoration, we will over this request, in future. Or she can depend on this.
All right, court will reset Ms. Cormier for status on placement and on the competency restoration list, October 15th.
Next, ready, on Mr. Donald Wood.
Donald Allen Ellis, CR 2483. Mr. Ellis is here on the state's motion to revoke.
Yes. I've met with the, or I requested an offer from the state on Mr. Ellis's motion to vote. I got received an offer on that, based on the comment, so the request be set on the August 27th docket for testing.
All right, court sets Mr. Ellis on the contested docket, August 27th at 1:30.
Then, there's no, asking around, we have these, waiting paperwork. That was Mr. Dyer, Mr. Harrison, Ms. Henderson, Ms. Martello. So I will, that's my top two numbers.
It's okay.
Next.
And I have the plea papers on Martell. I have those.
I don't know.
It's in my email. It says it's ready for me to review and sign. I'm gonna look at it and see. Just maybe the order got out of. Yeah, Miss Abney may have to resubmit that plea because I think it was delivered to me before it was delivered to Mr. Manning and the defendant and probation if they were involved. All right, so Mr. Manning, you need some time. Oh, Joyner. Miss Joyner, Alicia Renee Joyner, CR 2127. All right, Ms. Joyner's here on the state's motion to revoke.
Say that. This time, she is set already for testifying on August 27th. So still have reasonable.
All right, and I believe that she's already set for the 27th, but the court will confirm that court will proceed with a contested hearing on the state's motion to revoke August 27th at 1:30.
Does next ready on this regular meeting?
Keith Edward Looney, CR 26-1, CR 26-20. All right, Mr. Looney is set for pretrial.
There's a like request set to looking for a key date, we reached a resolution with the city. So we request to be set. It will be for time, so.
If we can't do it today, then the next date is the 25th or the 27th. 27th. All right, court sets Mr. Looney for plea August 27th at 1:30.
Next, ready on Mr. Bodlin.
Duncan Barry Maudlin, CR 2660. All right, Mr. Maudlin's here on pretrial.
Yes, Judge, this case is for requested discovery back on, August 7th. And, subsequently reached out, not to discovery at this point in time. I don't know as to what the issue is, but that's my plan of text. With that point, so I haven't received discovery on Mr. Paul's case, so go over them. Preparation.
State, any response?
Judge, I'm not aware of any issues. I've heard of it, so I'd be happy to follow up with that and be certain that he gets it as soon as possible.
All right, court's going to reset pretrial for August 27th.
Next, we have Mr. Nunez.
CR 25-184, CR 26-84, State versus Sean David Nunez on state's motion to revoke on the Class A misdemeanor assault, and then arraignment on the third-degree felony assault of a household or family member with previous conviction.
Yes, Judge. Mr. Nunez, please not go and insult the other 10 departments. And then in case, we are set for August 27th. For tested for judiciary. I request a local resolution that I'm not supposed to.
All right, the court enters Mr. Nunez's plea of not guilty into the record, finds he's waived the formal requirements of arraignment. Court enters his plea of not guilty into the record. Court sets Mr. Nunez for pretrial October 15th. And will carry the motion to revoke on even date. April Lynn Proctor, CR 15-104. All right, Ms. Proctor's here on the state's motion to revoke.
And this, I requested. 30 days. On July 2nd as well as August 7th. We have received any communication with you. So we've asked to carry forward our estimated to August 27th.
All right, court confirms Ms. Proctor will be given a contested hearing on August 27th at 1:30.
May have to go with you for stating.
Yes, sir. Mr. Weiner, you ready? Wendy Marie Jones. CR 13-368, CR 21-129. And Ms. Jones is here on motion revoke for third-degree possession and pretrial for first-degree manufacturer delivery. Any announcements on pretrial?
We don't have yet heard first time sitting this down in about 4 years, and to be honest, I have not gotten the file since you've been gone, so. What I'm respectfully requesting, and I spoke with Ms. Curry, is about 30 days for me to go through the file. I think we're gonna have an agreement, but I'll double check everything, just it's been so long.
Any objections from the state?
No, Your Honor.
All right, court sets Ms. Jones for, you don't believe there's any pretrial issues, right?
I don't believe so, but I'd like to reserve an on this case, that is.
All right, court sets Ms. Jones for docket call on, I've got the 15th and the 17th, if one of those is better than the other for you.
Let's do the 15th at 1:30 on.
15th, 1:30.
That'll agree.
All right, court sets Ms. Jones in for October 15th. And if there's a pretrial issue, then just let me know, Mr. Weiner, we'll work it out.
Thank you, Judge.
James Russell Chandler. This is cause number CR 26-79. And Mr. Chandler has been indicted with a third-degree felony offense of evading arrest or detention with a vehicle, and he's set for arraignment. Go ahead, Mr. Weiner.
Yeah. Installed correctly, we understand the nature of the allegations, like it's the way formal reading of the charging is been asked to go down, maybe not. This time.
All right, the court enters Mr. Chandler's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets this matter for pretrial on September 15th at 1:30.
But just, or will he go back or will he say here? That's the.
He was-
And.
He was benched from where, Henderson? He will likely go, is it easier for you if he does go back?
Much to make like a ping pong ball for him, it actually is easier. So resolve it and insurance.
Okay, then we can make a request that he be sent back to Henderson County. Does he have, he has charges in Henderson? Okay. We'll make a note to notify the sheriff's office that he can be released on the bench warrant and returned to Henderson County. That way you counsel with him over there.
Thank you very much.
You're welcome. Yes, thank you, Mr. Weiner. Good to see you.
Good to be here with some names.
It's better to be back in the courtroom for sure.
It is.
Awesome. Oh. Oh, okay. So you lost it from this Boston. Oh. They said Wasser. Wasser. I got you. I got you. I got you. Roger Dale Gamons. Give me just one moment, Mr. Gamons. Mr. King is appearing online. We're gonna get him set up here. All right, good afternoon. Good afternoon, Mr. King. Can you hear me okay?
I can hear you just fine.
All right, excellent. And can you see your client, Mr. Gamons?
I can see Mr. Gammons.
Good. Okay, we are on record in cause number CR 26 dash
Just one moment,
36.
Mr. Gammons. Mr. King is appearing
Sorry.
online.
Okay, just
There we go. I was listening to the YouTube stream, trying to make sure I didn't lose anything. So,
okay, yeah. If you'll just mute that or turn
Yes,
that
sir.
off, so we don't have a loop. Okay, Mr. Gamons is set for pretrial today. Any announcements?
Not at this time, Your Honor. We're just asking to be set for a docket call.
All right, court finding there are no contested pretrial issues. The court sets Mr. Gamons for docket call. Mr. King, I got a couple dates in September, the 15th or the 17th, if one's better than the other.
The 17th is better for me, morning or afternoon.
Okay. Since he's in jail, it'll be an afternoon setting. So court sets Mr. Gamons September 17th at 1:30. And that'll be for docket call. And we're gonna have him sign a notice of appearance and we'll give him a copy of that.
Thank you very much, Your Honor.
All right, thank you, Mr. King. Appreciate you.
May I be excused?
Yes, sir.
All right, thank you.
Mr. Rosser, come on up. This is cause number CR 21-239, State of Texas versus Isaiah Jabrier Rosser. Mr. Rosser, you are here on the state's motion to adjudicate. Is it my understanding that you wish to hire an attorney to represent you on this issue? All right, so what I can do, Mr. Rosser, is I can reset you until September 17th and give you time to hire an attorney, okay? So it'll be September 17th at 1:30. You'll be ordered back in person, okay?
Yes.
We're going to give you a notice of appearance for you to sign. They'll have that date on there, and then you'll be free to go. Remember, just because the state has filed a motion doesn't mean that you are off of probation or community supervision. You still need to report and do everything that you're supposed to do monthly. Otherwise, if you don't do those things, the state could amend their motion and add new violations, okay? So make sure you're staying in contact with your probation officer. Yes, it'll be at 9 o'clock. And Mr. Officer, make sure that you're talking with a criminal defense attorney, and one that's willing to practice here in Van Zandt, that's willing to come here, okay? All right. It's all right. I'm just going to take a recess and then you can give them time. All right, court's going to stand in recess, allow Mr. Manning and Mr. Schmidt time to speak with their clients. Court's in recess. I'm sorry, I can't hear you. Well, just give me some names because I'd have to. Wilson, Logan. Oh, Nelson, you said Nelson? Oh, yes, I have Nelson ready to go. Mr. Nelson? All right, court calls, cause number CR 26-30. And CR 26-38, State of Texas versus Stephen James Nelson. Give me just one moment. Let me pull your paperwork up. Hmm. First line didn't work. There it goes. All right, Mr. Nelson, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Your name is Stephen James Nelson, is that correct? And Mr. Nelson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? Okay. You don't have any kind of mental condition now that's impeding your ability to understand what's going on? Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work that he's done for you? Do you have any questions about any of the paperwork that you've read and signed today? Mr. Schmidt, do you believe Mr. Nelson to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily? All right. And what kind of credit time is Mr. Nelson entitled to in this plea agreement? 184. All right, Mr. Nelson, you are charged by indictment with a second-degree felony offense of assault of a peace officer or judge. That does carry a range of punishment of not less than 2 years or more than 20 years and a potential fine not to exceed $10,000. I see that there is a plea agreement in the case. Upon you pleading guilty, the state's recommending that the court consider the evidence, convict you of the offense, and assess your punishment at 5 years confinement in the Texas Department of Criminal Justice. There's also a recommendation for a $1,000 fine plus court cost of $290 and a reimbursement fees of $20, and you would receive 184 days credit towards that sentence for the time that you've already spent in jail on this case. Is that your understanding of the plea agreement, what you're asking the court to approve? All right, Mr. Nelson, how do you plead to assault of a peace officer or judge?
Guilty.
Are you pleading guilty to this crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Court also admits in evidence the stipulated evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state?
No.
From the defense? All right, court is going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court does follow the plea agreement today. Court convicts the defendant of assault of a peace officer, second-degree felony, assesses punishment at 5 years confinement in prison, orders a $1,000 fine, court cost of $290, and reimbursement fees of $20, and awards 184 days credit towards that sentence. Mr. Nelson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you're released from prison, if you've not paid off your fines, court costs, and fees, you need to report to the courthouse to do so. Failure to do so could result in the court issuing a warrant for your arrest for failure to pay fees, okay? All right, I'm gonna have you step over to be fingerprinted. Also, for the record, the court is dismissing CR 2638 on the motion of the state. Joshua Logan. This is cause number CR 26-55, State versus Joshua James Logan. Mr. Logan, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Mr. Logan, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? Couldn't hear you. Okay. In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? Do you understand everything that you've read and signed today that's part of your plea agreement? Mr. Schmidt, do you believe Mr. Logan to be competent to enter into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after you've advised him of his legal rights, including the advantages and disadvantages of a deferred adjudication plea? All right, Mr. Logan, you are charged by indictment with a second-degree felony offense of possession of a controlled substance that does carry a range of punishment of not less than 2 years or more than 20 years confinement in prison and a fine not to exceed $10,000. I see that there's a plea agreement in your case wherein the state's recommending that the court defer a finding of guilt and place you on community supervision for a period of 4 years, including a $1,500 fine, $180 restitution, $290 court costs, and $520 in reimbursement fees. And as part of the plea agreement, the state is disposing of, looks like 3 unfiled cases, possession of marijuana, possession of controlled substance ×2. Is that your understanding of the plea agreement? All right, Mr. Logan, how do you plead to possession of a controlled substance, penalty group 1, greater than 4 grams, less than 200 grams? Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt. Court admits the stipulated evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense? All right, court will review the evidence. All right, the court having reviewed the evidence finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court defers the finding of guilt, places the defendant on 4 years community supervision, assesses a $1,500 fine, court cost of $290, reimbursement fees of $520, and restitution of $180. And the court dismisses under section 1245 those offenses alleged in the judgment: possession of marijuana less than 2, possession of controlled substance 1 to 4, and possession of controlled substance less than 28 grams. Mr. Logan, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted by Sergeant Martinez. After that, when you go back to the jail, once you get processed out, you'll have a card from Miss Burns here for you to either report upon being released today or at whatever other time she tells you to be there, okay? All right, go ahead and see Sergeant Martinez. Charles Wilson III. All right, Mr. Wilson, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Wilson, your name is Charles Wilson III, is that correct? And this is in cause numbers CR 26-19, CR 26-18, CR 26-17, CR 26-68. Mr. Charles, or I'm sorry, Mr. Wilson, are you a United States citizen who reads, writes, and speaks English?
Yeah.
Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? You understand everything that you have read and signed today that's part of your plea agreement. Do you have any questions before we proceed further? Mr. Schmidt, do you believe your client to be competent to enter into this agreement? And if so, he's doing it intentionally, knowingly, and voluntarily after you've explained to him his legal rights? And how many days credit does Mr. Wilson have towards this sentence? 218. All right, Mr. Wilson, in cause number CR 26-68, you are charged by indictment with a third-degree felony offense of tampering or fabricating with physical evidence. That does carry a range of punishment of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that full range of punishment? And you've reached a plea agreement with the state today, is that correct? And it appears that that plea agreement is upon you pleading guilty, the state's recommending that the court assess your punishment after conviction at 4 years confinement in prison, along with a $1,000 fine, $290 court cost, and $20 in reimbursement fees. And you would receive 218 days credit towards your sentence. In addition, there are some cases that the DA's office is rejecting and dismissing. They have filed motions to dismiss in CR 26, 17, 18, and 19. Those are your 3 assault of a public servant offenses. They filed motions to dismiss those 3. And then also they are agreeing to reject and take into consideration with this plea an escape while arrested or confined, a criminal trespass, a possession of controlled substance, and a resisting arrest. Is that your understanding of the plea agreement? All right, Mr. Wilson, how do you plead to tampering or fabricating with physical evidence? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court does accept the defendant's plea of guilt. The court admits the stipulated evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court convicts the defendant of tampering or fabricating physical evidence. At third-degree felony, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, orders the defendant to pay a $1,000 fine, $290 court cost, and $20 in reimbursement fees. And the court dismisses CR 2617, CR 2618, CR 2619, and takes into consideration under Section 1245 those cases read into the record by the court on the escape, criminal trespass, possession, and resisting arrest. Court hereby awards Mr. Wilson 218 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Wilson, once you're released from TDC, if you've not paid off everything that you are court ordered to pay, then you are to report back here to the courthouse to make payment. If you cannot make payment all at once, then the county will enter into a repayment program with you. And so as long as you make an effort, then county will let you pay that off. If you do not make that effort, then the county could request that a warrant be issued for your arrest. Do you understand? All right. I'm gonna have you, you're gonna be remanded to the custody of the sheriff. I'm gonna have you step over there to be fingerprinted. Patricia Martell. CR 2692. State versus Patricia Diane Martell. All right, your name is Patricia Diane Martell, is that correct? Ms. Martell, if you'll raise your hand, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Ms. Martell, are you a United States citizen who reads, writes, and hang on, let me finish the question. Are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Manning. Are you pleased with him as your attorney? Do you understand everything that you've read and signed? Do you have any questions? Mr. Manning, do you believe your client to be competent to enter into this plea agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after having been informed of her rights, including the right to an indictment in the case, the waiver thereof, and the advantages and disadvantages of a deferred adjudication plea? All right, Ms. Martell, the first order of business, let's talk about your waiver of indictment. You've asked the court to approve your waiver of your indictment. Do you understand what waiving your indictment means? You understand that you are giving up the right to have your case presented to a grand jury, and you're allowing the state to prosecute you by filing a legal instrument known as an information. You understand that? And has anyone threatened you, forced you, or pressured you to do that? And you've had the assistance of your attorney to walk you through that process. Is that correct? And you feel like you fully understand it? All right, the court will find that the defendant has been admonished of her right to an indictment in this case and has waived the same intentionally, knowingly, and voluntarily. Ms. Martell, you are charged by information with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than 1 grams, less than 4 grams. That does carry a range of punishment. If you were to be convicted and sentenced to not less than 2 years in prison or more than 10 years in prison, and you could also be fined up to $10,000. Do you understand that? I see the plea agreement in the case. Upon you pleading guilty, the state's recommending that the court defer a finding of guilt on your case. They're recommending 6 years of community supervision, a $1,000 fine, $180 restitution, court cost of $290, reimbursement fees of $515. And also the DA's office is asking the court to consider, as part of this plea, 2 unfiled cases: possession of marijuana less than 2 ounces and possession of controlled substance 1 gram to 4 grams. Is that your understanding of the plea agreement? All right, Ms. Martell, how do you plead to possession of a controlled substance in penalty group 1 greater than 1 grams, less than 4 grams? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court does accept the defendant's plea of guilt. Court admits the stipulated evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court is reviewing the evidence. All right, the court has reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court defers a finding of guilt, places the defendant on 6 years community supervision, orders her to pay a $1,000 fine, restitution of $180, court cost of $290, reimbursement fees of $515. Court does dismiss under section 1245, DA 2026-651, possession of marijuana less than 2 ounces, and DA 2026-650, possession of a controlled substance 1 grams to 4 grams. Ms. Martell, you're hereby remanded to the custody of the probation department, and I'm gonna have you be fingerprinted with Sergeant Martinez. After that, Ms. Burns, the director of our probation department, if she hasn't already, will give you information about when you will report to probation, okay? Do you have any questions? All right, go ahead and step over there to have your fingerprint. Have you already told all these people? So I can say that. Sherry Henderson, CR 2698. This is also in CR 2699. Ms. Anderson, if you'll raise your hand, please. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Sherry Dale Henderson, is that correct? And Ms. Henderson, are you a United States citizen who reads, writes, and speaks English? You have to say out loud. My court reporter's typing down. Okay. And have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning as your attorney? Do you understand everything that you have read and signed that's part of your plea agreement? Do you have any questions? Mr. Manning, do you believe your client to be competent, and if so, that she's entering into this agreement intentionally, knowingly, voluntarily, after having been advised of her legal rights, including the advantages and disadvantages of a deferred adjudication plea? All right, Ms. Henderson, you are charged with a state jail felony offense of possession of a controlled substance. That does carry a range of punishment. If you were to be convicted and sentenced, it would have to be somewhere between the minimum 6 months to a maximum 2 years in a state jail prison. You could also be fined up to $10,000. I see that there is a plea agreement in your case. Upon you pleading guilty, the state's recommending that the court consider the evidence, defer a finding of guilt, meaning the court would not convict you today. Rather, the court would place you on 3 years of community supervision. They're recommending a $1,500 fine, $180 in restitution, $290 in court cost, and $520 in reimbursement fees. They're also making an agreement with you that they would dismiss cause number CR 26-99, which is an unlawful carrying of a weapon, in which you are agreeing to forfeit the weapon that was seized in that matter. And the state is also agreeing to reject or decline the prosecution of a possession of a controlled substance that is currently unfiled. Is that your understanding of the plea agreement? All right, Ms. Henderson, then how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Court admits the stipulated evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court reviews the evidence at this time. The court, having reviewed the evidence, finds enough evidence to convict the defendant. Court will follow the plea agreement. Court defers the finding of guilt, places the defendant on 3 years community supervision, assesses a $1,500 fine, $180 restitution, $290 court cost, $520 reimbursement fees. The court dismisses CR 26-99, unlawful carrying of a weapon. The court orders the forfeiture of the weapon seized in that matter. Furthermore, the court disposes of the unindicted cases of DA 2026-641, possession of a controlled substance in penalty group 2. Ms. Henderson, you're hereby remanded to the custody of the probation department. Once you you get your fingerprint and you go back into jail and get booked out, then you'll need to meet with the probation department as directed. Do you understand? All right, please step over to be fingerprinted. Ronald Suggs. This is cause number CR 26-39. State versus Ronald Gary Suggs. Mr. Suggs, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court would be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Suggs, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon that does carry a range of punishment of not less than 2 years or more than 20 years and a possible fine not to exceed $10,000. You understand that full range of punishment? Okay. Are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? You're represented by your attorney, Mr. Manning. Are you pleased with him as your attorney? Do you have any questions about your paperwork or anything else? Mr. Manning, do you believe Mr. Suggs to be competent to enter into an agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights and being advised of the advantages and disadvantages of a deferred adjudication plea? All right, Mr. Suggs, the plea agreement appears to be upon you pleading guilty, the state's recommending that the court defer a finding of guilt for the court to place you on 10 years of community supervision, a fine of $2,500, court cost of $290, reimbursement fees of $520. And as part of the agreement, the state is dismissing all other counts of 1 through 6 and number 8 on the indictment, and they're declining an unfiled case of tampering with a witness in a family violence case. Is that your understanding of the plea agreement? All right, Mr. Suggs, how do you plead to aggravated assault with a deadly weapon? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Court will admit the stipulation of evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state? Mr. Hernandez, can you comment on whether the victim is supportive of this plea for community supervision? Yes. Mhm. Yes, yes. Oh. Everything is on the record. I will mute you. All right, thank you, Mr. Hernandez. Anything further from the defense? All right, court is reviewing the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement today. The court places the defendant on deferred community supervision for a period of 10 years, orders the defendant to pay a $2,500 fine, $290 in court cost, $520 in reimbursement fees. Court finds that the state has agreed to dismiss counts 1 through 6 and number 8 on the indictment, and the court finds that the state is resolving unfiled tampering with a witness case and family violence case, DA 2026-165. Mr. Suggs, you hereby remanded to the custody of the probation department. Once you are released from jail, you'll need to report as directed. I'm gonna have you step over to have your fingerprint taken. Mr. Manny, do you have any more, please?
Go over that, I received a lot.
Okay. Do you have any other announcements you want to make?
Should, announce Mr. Tatum. All of it.
Mr. Tatum, if you'll come forward, sir. This is cause number CR 2669, State versus James Terry Tatum. All right, Mr. Tatum, set for pretrial.
Yes, Judge. If previously request you would like is jury setting. I know the court said this for a pretrial at this point. I have reviewed the discovery, and, Mr. Tatum would still like his jury set.
Okay. So does that mean that Mr. Tatum does not want to engage in plea negotiations with the DA's office?
That's correct.
And that means he rejects any plea that could ever be offered by the DA's office.
Judge, I've spoken to him about that, but I'll make sure that he understands that here in the court. Mr. Taylor, do you realize that if we go ahead and set this for jury selection, that there's not been an offer made, and if there was an offer made, judge will not accept that offer after we pass this time, you understand that? Okay. And it's still your, or desire to have a jury listen to the facts in your case and decide whether to be the offer for did. But you still want the jury to hear your facts or your case and decide whether you're guilty or not guilty. That's right. Okay.
Okay. Is the state intending to make an offer at all to Mr. Tatum, just for purposes of the record?
Not been entertained that thought, Judge, since he's not been open to it.
Okay.
No.
Yeah, very well. Okay. Anything further, Mr. Manning? Are you and Mr. Tatum talking?
Judge, we are just ready to jury selection thing for Mr. James.
All right.
We're gonna make that.
All right, court's gonna set Mr. Tatum. I understand that this is an aggravated assault deadly weapon. The court may end up specially setting it. I'm not gonna specially set it today. So we're gonna put him on the rolling trial docket beginning August 31st. And if there is a special setting, I'll notify counsel.
Yes, sir.
At least. And I think, Mr. Manning, my special settings are booked up until January. I think January is the first, potentially the first time that I don't have a special setting.
But what I'm just saying is that his cases are set till January. He has each of those dockets full till January. So if a case gets resolved, we may get decided at that spot, but he would not have space for your case until at least June. You understand that?
So I'm on the 31st.
You will have to reset at that time, but most likely will not go to trial at that time. You understand that?
That's right.
And Mr. Manning, let's make sure that he understands that he's dispensed with plea negotiations. The state's not even. Hang on. I need you to be quiet, Mr. Tatum, and let your attorney do the speaking for you.
But he's having a hard time.
No, I know. Just tell him to quit talking. Let you do his talking. I want him to make sure that he understands that his trial may not be had until next year. And that if he doesn't want that to occur and he wants some kind of disposition prior to that, he's telling us today that he wants a trial, and that may not occur until 2027. And the DA's office is not going to go jump through hoops to make him an offer if he's not willing to accept one. I want to make sure he understands he's given away the negotiation factor, and B, asking for trial, but that trial is definitely not going to be on August 31st.
Judge, and Mr. Tatum was not able to hear, what the court was saying, so if I may just.
Sure, yes.
The judge is trying to let you know that if you ask for a trial today, I understand.
I'm not guilty, I didn't make a little gun on me earlier.
And so, in asserting your innocence, the only way that's gonna happen is when you go either to trial or they dismiss the case, okay? And so, you've let this court know you don't want to take any type of deal, regardless of what it be offered. You're not interested in any sort of negotiations, is that correct? No. And you understand that today's the last day you can make that decision? Okay, and you're still saying you're not guilty, you have a legal defense, and you want to jury to hear that. I understand, and you understand that I've done, what you've asked, to move these cases fast, as the judge would allow to go forward, understand that? Yes. Okay.
And he understands he's not the only person in this county that's wanting a trial.
You just want to remind you, you're not the only person who wants to try.
All right. Thank you, Mr. Tatum. Court is going to set, or has been set, Mr. Tatum for jury selection beginning August 31st on the rolling docket. And if we can get a special setting, I'll notify the state and council. Who's next, Mr. Manning?
Judge Mr. Oliver.
Marcus Lynn Tolliver. This is cause number CR 25-139. Mr. Tolliver's here on docket call.
Judge Oliver, during your trial, I had not spoken to him about, horses and insurance. Although I believe he did hear those, and he realizes the same for the following. If I may, just ask if you so proceed.
Yes, sir, please.
Judge, my client, to request one additional study, so that we can find out, see if there is any negotiations he had, and there's an offer to be on the table. he would require some more time on the policy.
All right, I'm gonna short set him for 2 weeks,
Yes, Judge.
August 27th. Final docket call. Anyone else, Mr. Manning? Got Mr. Simmons, Mr. Mesa.
Judge, and speak with, before the-
Sure, me stand in recess like 15 minutes, 20 minutes,
Judge,
a little more?
Could you please discuss?
Okay, sure. All right. Just note the time is 10 till 4. Court will stand in recess until you're ready, Mr. Manning.
additional explanation, we will want to see one of those movies. So there's some, apparently there's some difficulties with, Mr. Harrison's paperwork, so we're gonna request that we send him the 27. We should have Mr. Diamond paperwork.
I don't see Mr. Dyer yet. Let me double check that. Was it recently?
Yes, Judge.
Let me see if Miss Burns has it. I've been distracting her, so. All right, Mr. Hairston. Come on up. This is cause number CR 24-72. And you said you want to set that for plea on the 27th?
Yes, Judge.
All right, and I see that we are set for pretrial today. Court finds there are no pretrial issues. Court will set Mr. Harrison for plea before the court, August 27th at 1:30. We'll give him his notice of appearance. Did you have it, Karen? Mason Dyer. Hang on. I need a court reporter. I need my court reporter. I'm not worried about Mr. Hairston on the record, but we'll definitely get Mr. Dyer on the record. What'd you say? Okay. It'll be just a moment for Miss. We're waiting on Miss Grisham. I forgot to get her earlier, so. Ouch. Oh, I'll let you borrow a molar. I got an extra molar. Let me give it to you. Molar. All right, court's on record in CR 26-91, State of Texas versus Mason Ryan Dyer. Mr. Dyer, if you raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, thank you. Can lower you. All right, your name is Mason Ryan Dyer, is that correct?
Sir.
And Mr. Dyer, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning as your attorney? Do you have any questions about the paperwork that you have read over and signed today? I see here that you are asking the court to allow you to waive your right of indictment and to plead to an information. Do you understand that by waiving your right to an indictment, you're waiving your right to have the case presented to a grand jury, and you're allowing the state to prosecute you by filing an information? And you've talked about that with your attorney, Mr. Manning, and he's explained that to you. Is that correct? You understand that if I approve this waiver, you may not get that right given back to you if you decide to change your mind later? All right. Has anyone threatened you, forced you, or pressured you to waive your right to an indictment? All right. The court will approve Mr. Dyer's waiver of indictment, find that he's been admonished regarding that right and that he's received the assistance of counsel in making his decision. All right, Mr. Dyer, I see here that you are charged by information with a third-degree felony offense of possession of a controlled substance in penalty group 2 between 1 grams and 4 grams. That third-degree felony does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also a possible fine not to exceed $10,000. I see the plea agreement in the case is upon you pleading guilty. The state's recommending that the court defer a finding of guilt. That means not to convict you. They're asking the court to place you on 3 years of community supervision. They're asking the court to assess a $500 fine plus restitution of $180. And you would also be responsible for court costs of $290 and reimbursement fees of $515. Is that your understanding of the plea agreement? Mr. Manning, do you believe your client to be competent to enter into this plea agreement? And if so, he's doing it intentionally, knowingly, and voluntarily, understanding what his rights are and the advantages and disadvantages of a deferred adjudication plea? All right, Mr. Dyer, how do you plead to possession of a controlled substance in penalty group 2 greater than 1 gram, less than 4 grams? Are you pleading guilty to that crime because you're guilty of committing the crime? Has anyone threatened you, forced you, or pressured you to plead guilty to this crime? All right, the court does accept the defendant's plea of guilt. The court admits the stipulated evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Okay.
Anything further from the defense? All right, court is reviewing the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Before I go any further, I noticed that in the plea agreement, there's a requirement stated that the defendant must have a home address as a condition of community supervision. Is that issue resolved?
Judge, that, one of Ms. Curry's concerns was, that she believed him to be, without a home, or permanent home. I spoke to him, and he is anticipating, once he's released, to get an apartment with some friends of his as a, as he gets to see better with him. And so, while we haven't necessarily negotiated that term, he is willing to, follow the term as a condition. We should find out address, and have that.
Is that an issue with community supervision?
Yeah.
Okay, let us confirm what address. They're gonna have to have an address where they can do a field visit to make sure they're doing their job. Go at, just ask him. Show Jonathan. Yes, sir. Yes, sir.
Judge, as she has, is a good address and where he will be staying.
Okay. And he's gonna provide that to probation at the conclusion of the plea?
It's already, it's already.
You already have, it? Okay, good. All right, then the court hereby follows the plea agreement. The court defers a finding of guilt, places the defendant on 3 years community supervision, orders him to pay a $500 fine, restitution of $180, court cost of $290, reimbursement fees of $515. And the court hereby remands him to the custody of the probation department so they can carry out the terms and conditions of this sentence. Mr. Dyer, how old are you? 18. You're 18 years old. Do you graduate high school? You're 18 years old and you're already on felony probation with a potential sentence of over 10 years or at 10 years hanging over your head. What are your plans to avoid prison? You understand that you're going to have a lot of decisions to make. And for 3 years, all of those decisions are going to be scrutinized by your probation officer, by these assistant district attorneys, potentially by me. All right. So every decision that you make needs to be focused on how to comply with your conditions of community supervision so that you don't end up a convicted felon for the rest of your life. You understand that if you get revoked and sentenced, you'll be a convicted felon for the rest of your life. And that will be on your criminal record. That will affect you in a lot of aspects. Your ability to get a loan, your ability to get an apartment, your ability to get a job. It's going to limit you. Okay. It's going to make things harder on you. So you have an opportunity here to avoid that. The DA's office has been gracious enough to grant you that opportunity. And so you need to take them up on it and be appreciative of it and make sure that you are complying with every condition of your probation. You need to make sure that your probation officer is your biggest fan. That means you got to bend over backwards. You got to jump as high as you can to please them. And that means a 9 to 5 job. You might need to be working a 5 to 9 job, right? Going the extra mile. You understand? I'd hate to see you come in here and get convicted and end up in prison as such a young man. You understand? All right. So I want you to be, every time before you make a decision about anything, I want you to ask yourself, is this in the best interest of me and my probation? And if you can't, if you're wondering if it's a good decision, then I'm telling you it's a bad decision. If you have to stop and think about it, you already have your answer. You understand? All right. And there's people here that are supporting you, right? People here that care about you, right? You need to reciprocate that. You need to show them that you care about them caring about you. Does that make sense? All right. I'm gonna have you step over to be fingerprinted. When you're released, you'll report to probation as directed. Christopher Wayne Blevins, CR 25-154. Sergeant Martinez. Sorry. All right, Mr. Blevins is set today on state's motion to revoke.
Yes, sir. I'm gonna pass. Setting, for resolution, is.
All right, court sets Mr. Blevins to enter his plea on August 27th at 1:30. And if he decides he doesn't want to enter the plea, then we'll move forward with a contested hearing.
Yeah.
You ready, Mr. Mesa? Dylan Ray Mesa, CR 19-147. All right, Mr. Mesa said on Stacy's motion to vote.
Yes, sir. These. Only substantive allegation using. I am representing him. Under the other situation, potentially reach global revolution. They, our request to the state, and we hope to have it done before the 27th. Better we'll go forward on the same.
All right, court notes your announcement, and we're set August 27th.
Do we have to set Mr. Mesa? Or?
No, I believe he's already set. All right, you ready on Mr. Simmons?
Yes.
Levi Aaron Simmons, CR 2665. All right, Mr. Simmons is set on pretrial.
Yes.
All right, court will set. I'm gonna set him for pretrial and final docket call on October 15th.
or
15th.
Dang.
I'm sorry, I probably didn't enunciate it very well. Is that all your cases, Mr. Manning? We did him when you were out. That's when I realized you were out, and we've reset him. $827 per plea. Yeah, I don't show any more to be pending. All right. All right, that concludes the court's afternoon docket. We are adjourned. Thank you, Mr. Hernandez. Thank you, Mr. Hall. Thank you, Mr. Manning. Yeah, that's when I realized you were gone. I looked down, I was like, oh, there she's not here. Hey, do you remember the time that Judge Drum did that in a murder case?